In this installment of Washington Legal Foundation's Legally Brief, Thomas Gorman, a partner at the law firm Porter Wright, a former senior counsel at SEC's Enforcement Division and author of the popular blog SEC Actions, examines the impact of an SEC decision to delegate the authority to issue formal orders of investigation to the Director of the Enforcement Division.
Thank you, Glenn. The new rule that's been put out by the SEC delegating authority to the Director of the Division of Enforcement to issue a formal order of investigation is a very significant change, which should be of concern to almost anyone within the jurisdiction of the SEC. And in fact, I think that it should be of concern to the staff itself. First, let's look at what the rule does. Previously, under the prior procedure, the SEC commissioners were the only ones that could issue a formal order of investigation. And that order is significant in the life and the development of an investigation by the enforcement staff because it directs the staff what acts and practices to investigate, first of all. And second, and more importantly, it gives the staff the authority to issue subpoenas to investigate the particular transactions and practices that are described within the formal order of investigation. So while it's not quite like a complaint in a lawsuit, it at least gives the broad parameters of the authority of the staff and then empowers them to go and investigate certain acts and practices. Under the new procedure, the decision that was previously made by the commissioners is now going to be made by the Director of the Division of Enforcement. This raises really two significant issues that I think should be of concern to everyone. First, there's a question of independent judgment. Under the prior practice, as I said before, the order of investigation was issued by the commissioners, not by the staff. The staff are the people who are conducting the investigation. They're usually the proponents of the investigation. They're the ones who want to go forward with it. Under the traditional practice, as written in the statutes since 1933, when the first of the securities laws was promulgated, it was the commissioners, on application from the staff, who made an independent judgment. They were something like a judge in a court listening to an application from the staff. Should we do this? Shouldn't we do this? So there was not a rush to judgment. Under the modified procedure, the delegated authority procedure that we're going to have now, it's going to be the same staff that wants to go forward with the investigation, making the decision if they should go forward with the investigation. The whole independent decision-making process is lost. You've got really what's an inherent conflict of interest that I don't think any court would put up with in any kind of judicial procedure. So that's one point of concern. Now, some people would say, well, issuing this order is relatively routine, and to a certain extent that's true. Orders are issued all the time. At the same time, there was a moment of reflection there because when the staff had to apply for a formal order, they had to sit down and write a memo. They had to talk about it with the senior staff people and justify it. They had to take it to the commissioners and justify what they wanted to do. So there was not only a moment of reflection, but the independent judgment. That's now lost. More importantly is a second point that I think is important here, and that is I see this order as a loss for everyone. It's a loss for the staff and the commission. It's a loss for those within the jurisdiction of the SEC, and here's why. Under the prior procedure, the staff could conduct an informal investigation on a voluntary basis. There was no subpoena power, there was no directive, and oftentimes the staff would conduct these investigations, and oftentimes the companies and the individuals involved would voluntarily cooperate. Routine matters were oftentimes frequently resolved fairly quickly, fairly inexpensively. The staff didn't have a lot of time in it. The issuers and the individuals didn't have a lot of time, expense, and burden for it, and the thing was resolved. Under this process, the staff is going to be more likely to simply issue a formal order, and once that happens, those investigations tend to take on a life of their own. The voluntariness of the informal process is now lost, and this takes on a process of its own where the staff is committing time and resources. It's a formal process of issue subpoenas for documents, issue subpoenas for testimony. On both sides of the aisle here, what you have is a burden. The staff has to commit people to it, time, effort, money. On the company side, the individual side, the people receiving these subpoenas, it's the same kind of burden, and it tends to go on, and everybody knows many of these investigations last for a period of years. They're costly, they're time-consuming, and expensive. So I see this as really a lost opportunity to quickly resolve things in the beginning, which frequently happens with enforcement investigations where an informal process is utilized. Bottom line here is, I think this delegation is not a good idea. It really is a rush to judgment. While it will certainly speed up the start of a formal investigation, it will tend to lose the opportunity for the independent judgment of the commissioners. It loses the opportunity to quickly settle something in the informal process, and it tends to utilize the resources of the staff, and it tends to be a burden for those who are involved with it when it may not have been necessary to undertake this process at all. So hopefully, at the end of the year trial period for this, the Commission will decide that rushing into an investigation, not necessarily the best way to go. Really, the more deliberative process that has been traditionally used since the statutes were written is the way to go here because it gets the best results for all concerned. Thank you.